I have prepared a statement. I will try and reduce it, and I will hand my written statement over to one of your stewards later. It's 2011 since I last attended the meeting, and I will remind you then of what I said then when I did have the opportunity of addressing the meeting. I said, "Do you know that you preside over a bank that has absolutely no compunction about engaging in fraudulent activities?" Perhaps the media and the press room may be interested to learn what I have to say. Following that meeting, we did meet, and you stated that the bank took accusations of fraud very seriously, asking me to send details. I subsequently sent you a letter with the information, and supposedly having made inquiries, you did revert to me to write that you had found no evidence of any wrongdoing. Well, Chairman, since then I have been reading, researching and learning as much as possible about the conduct of this bank over the last 4 years. And having reviewed recently the American Securities and Exchange Commission website, it prompts me to ask you this question. When the SEC approached the bank, did you in any way respond, as you did with me, to the effect that the bank had done nothing wrong and could find no evidence of fraudulent conduct? If so, why does the following statement appear on the SEC website dated the 28th of April 2014? I quote, "In January 2014, a subsidiary of RBS was criminally convicted for its conduct in manipulating the London interbank offered rate, LIBOR. The scheme profited RBS to the detriment of individuals, businesses and governments around the globe. Under federal securities laws and regulations, this criminal conviction automatically precluded RBS from eligibility as a well-known seasoned issuer and the attendant benefits that our rules provide to WKSI filers. A second article on the website was another interesting disclosure, this being as recently as the 20th of May 2015, and concerning the fraudulent manipulation of the forex markets. Pursuant to the plea agreement, the settling firm, Royal Bank of Scotland Group, entered a plea of guilty, in brackets the guilty plea, on May the 20th, 2015, in the District Court to the offence charged in the information. In the plea agreement, the settling firm, among other things, agreed to a fine of $395 million. Very clearly, you and this bank have not taken the allegations I made at all seriously. You have demonstrated an unconscionable level of willful blindness towards the corruption and fraudulent conduct within the bank, and it has become very clear that you and senior executives have condoned all the criminal acts committed by the bank, which have now been exposed due to the diligence of the regulatory authorities in America. Chairman, one of the last letters emanating from your office states, "The bank does not accept the allegations you continue to assert." Well, I do acknowledge that I have tried to gain redress through the civil courts for the situation this bank forced us into, and that these actions were dismissed. However, since that time, I have been pursuing every alternative option available to me, and undoubtedly with the benefit of the exposures in Tomlinson and the fact that this bank has so spectacularly shot itself in the foot by attracting the attentions of the regulatory authorities as a consequence of the criminal activities I referred to earlier, I have now secured the services of several very astute and highly qualified experts in banking and criminal law. It has now become abundantly clear to me how your bank recklessly and knowingly ensured our total economic loss. Only last month, I secured a very positive legal opinion that has confirmed we have a case for fraud to pursue against the bank. In referring to my previous legal claims, the opinion states, and I quote, "In my view, these initial claims have been largely misplaced in terms of the arguments deployed, and those advising on such claims appear not to have understood the fundamentally fraudulent nature of the way in which the bank was behaving. There were recent exposures in the Times newspaper, and again, Chairman, you dismissed them. These disclosures clearly demonstrate from case histories with indisputable evidence the corruption sanctioned from the top of this company in destroying viable business customers for the sole gain of the bank. I understand that my business, and one other that I know of, involving this bank fraudulently administering loans available under Enterprise Finance Guarantee Initiative, were among those investigated by the Times before publication. Mr. Chairman, Council's opinion, with all the supportive evidence on at least these two cases, does not lie. I'll go to the end of what I've prepared, Chairman, and I just ask you to, when you do investigate our case, look at one small detail, and which is a subject of fact. How is it, when we deposited more cash with the bank that was due in loans, the bank refused to accept this to expunge those loans, but instead used the bulk of this cash for its own fraudulent benefit? Thanks to the work of the experts, I now know how the answer to this question that has baffled me for 17 years. I just wonder if the bank is now prepared to acknowledge its conduct and actions against us which arose solely from this recklessness. Finally, I will make this observation. To be respected is the best cover in the world for fraud. In fact, fraud could rarely exist without it. I believe that perfectly sums up how the Royal Bank was able to act in the way it did. Thank you.
First of all, the disclosures on the SEC website, I'm sure are accurate. I mentioned in my speech that the company bank, like many other banks, was involved in FX rigging and Nigel rigging, and because I mentioned the bank has no tolerance at all for that sort of behaviour, and has pursued individuals in all the ways that it can, and perhaps other agencies will be pursuing some of the individuals that are involved with those sorts of things. Most of that stuff was done pre-crisis, but not all. As I said, it has taken a while, I think, and I'm not sure the job is done to fully fix the culture, the behaviour in banks. But I think we're most of the way down the track. I would suggest to you that we're most of the way down the track. As to your own particular position, I do know that, because you recognise there have been court actions that you have brought against the bank, I believe 3 in the Court of Session in Edinburgh, and the courts have found in the bank's favour on each occasion. That is what our legal experts expected, and that is what did happen. So that there really, unless you have more information that you can bring to us, so that we can look at the case again, that I think is as far as we can take it. So it does appear to be a pretty decisive view of the courts. I hope you will acknowledge, although I know it is always really very difficult. I'm not sure when your own particular circumstances arose with the bank, but we did go through, particularly in 2008 and 2011, probably the worst financial crisis that anybody in this room has experienced. Probably the worst for 100 years, and I think I can be fairly confident I don't see very many centenarians. And that's a very tough time for people in business. It's a very tough time for banks. We had thousands, many thousands of companies that got into desperate trouble in that major downturn. And the stance of the bank, which I think was true in other banks as well, there really were very few defaults actually in that time, very few bankruptcies compared with other much less severe downturns. But the stance of this bank was to try and nurse as many customers as we could through those very difficult times. And I think that's what we did. We will not have got all of our judgments right. When you have many thousands of customers in distress, you are bound to make judgments which in some ways are too tough or not tough enough. There's bound to be some sort of distribution curve around the nature of the judgments that you make. So we've always accepted that we would make some of these judgments. That, I think, is inevitable. What we do refute is that we made systematic misjudgments in order to benefit from customers' distress. I see no evidence of that in this bank. I never have done. And we did appoint an independent firm of lawyers to see whether or not any behaviour of that nature could be identified, and none was found. And we appointed a firm of lawyers to do that separately in the United Kingdom, and another firm of lawyers to do it in Ireland. And again, no evidence of that sort of behaviour was found. As you may know, the Financial Conduct Authority is also responsible for these allegations. But as I say, Mr. Henderson, if you do have new information that you think is important to our judgments, then I would invite you to let us know.
Well, I will just say that you mentioned between 2008 and 2011. Our case dates back to, well, when we first became customers in 1997. And it was that point that the bank deliberately set out, and I'm not going to go into details of what it's about because it's beyond my partly beyond my comprehension, but it has now been uncovered by some of the experts who I say have been investigating our whole dealings with the bank. And I will say that the Criminal Counsel has forensically examined our case and is satisfied that it was fundamentally fraudulent. So I can't say more than that. Papers are in the process of preparation, and it's up to the bank if you want to speak to me.